Hall & Wilcox acknowledges the traditional custodians of the lands on which this podcast is recorded. We pay our respects to their elders, past and present, and to all First Nations people joining us today.
Hello and welcome to our podcast, Tax Records. In this series, we're examining the hot topics in taxation. My name is Frank Hinopoulos and I'm a partner and head of the tax team at Hall & Wilcox. Today, I'm delighted to be joined by my colleague and fellow tax partner, Jacqueline McGrath. In today's episode, we're going to be discussing the new Administrative Review Tribunal, which is the new iteration of the Commonwealth Administrative Appeals Tribunal. And before we talk about what's new, Jack, perhaps let's start with an overview of what the Commonwealth Tribunal has historically done and how it relates to tax.
Sure. So the Administrative Appeals Tribunal is, in essence, the federal administrative review body. It's able to review decisions made by different agencies. So some of you are familiar with tax is the obvious one, but it has had jurisdiction to review Social Security decisions, certain Migration Act decisions, the Commonwealth Compensation Scheme, Veterans and Repatriation Medical Authority decisions, most recently the NDIA as well. But back to basics, if a statute gives rights of review by the Administrative Appeals Tribunal to citizens from administrative decisions, then the tribunal is able to review it. So in the tax space, the tribunal has historically been one of two options to review certain decisions of the ATO. So taxpayers can either appeal to the federal court, who exercise judicial review, or alternatively, a taxpayer can apply to the Administrative Appeals Tribunal if they disagree with the ATO's decision or assessment. So historically, the reasons many choose the tribunal is because it is a low-cost jurisdiction, meaning that the application fee is generally less than the federal court. The tribunal can't award costs in tax matters, so each litigant has to bear their own costs, but also they don't risk having to pay the successful party. So it's also more informal in that the tribunal isn't bound by the rules of evidence. So it's really trying to be a very accessible place for reviews. So I think a lot of those things, accessibility, ease, little formality, is something that's still going to be part of the new tribunal.
Okay, thanks for that explanation, Jack. So we've gone from the Administrative Appeals Tribunal, the AAT, to the Administrative Review Tribunal, the, I don't know, what do you think it's going to be? The ART? Is that what we're going to call it? The
I think so, yep.
I might have made the juvenile joke to Jack once or twice that it's probably fortunate it wasn't called the Federal Administrative Review Tribunal. But so aside from what's in the name, Jack, what's going to be different in our experience as users, and what should practitioners expect is going to change in the new ART?
So there's a few things. I think the ones that I want to talk about are really in two groups, but there's a lot more. But I wanted to chat through two of them. The first is the creation of what's called the Guidance and Appeals Panel, or the GAP. So lots of acronyms. This is probably the most fundamental change in the new Administrative Review Tribunal. The second is that the respondents now, so agencies whose decisions are the subject of review, can elect not to participate in proceedings. So the GAP is probably the most significant change proposed by the Administrative Review Tribunal Act of 2024. There's really nothing comparable in the current regime. The explanatory memorandum to the new provisions says that the idea of the GAP is to escalate systemic issues, improve the quality and consistency of tribunal decision making, and increase confidence in decisions. But as the name suggests, the GAP is really aimed to perform two functions. The first is to act essentially as an appeal step from certain decisions of the tribunal that are considered to be of significance. So if a taxpayer's already had a review undertaken and as a decision given by a tribunal member, they can apply to the president of the new tribunal to have the GAP convene to hear an appeal. But the provisions also allow the president on their own motion to refer it to the GAP. So the idea of the GAP is that it will be presided over by two or three senior members, one of which will be the president or a deputy president. And the EM also speaks about, particularly, I think, for the tax jurisdiction, having judicial deputy presidents. So judges of the federal court to be able to sit as part of the GAP. So the EM emphasises that this is really a reflection, in tax matters, particularly that are legally complex or highly contentious.
Excellent. So you use the terminology there around an issue being a significant issue. I can just see it now. No client is going to think that their issue is an insignificant issue. But is there any actual guidance about what may be considered a significant issue?
Well, I understand that there are some practical guidance materials to be released that's still being worked through. But at least from the explanatory memorandum, they talk about matters where it looks like the decision would have broad implications. So similar facts or issues are coming before the tribunal and the GAP wants to get some guidance or give some guidance, I should say, for members about the approach in those decisions. So I think obviously there's more to come on all of this, but I think if we think about the reasons that there was a review into the AAT a couple of years ago, what was the impetus for that? And one of the major reasons was robo-debt, and specifically that there were decisions coming before members in the social security jurisdiction within the tribunal that were seeing kind of the breadcrumbs of a potential issue. So the idea of the GAP is really that it uses the language in the EM that systemic administrative issues can be raised to the attention of the president, and that there's a reporting mechanism for this. So I suppose, I guess with that complexion, I think that what would be significant that would warrant the GAP would probably be things like any developing trends in agencies' decisions. So seeing what has been, or the sorts of things that have been appealed. But it can also be, of course, wanting to ensure consistent decision making for these types of matters. Again, one of the overarching principles of the new regime is to ensure consistent and timely decisions. And I think the GAP is really a measure to assist overall with that goal. It can provide guidance to other members, so who will sit and determine other similar cases.
Thanks so much for that explanation, Jack. And I think before we got talking about what would be a significant issue that would warrant the GAP process, you were talking us through some of the what you see as some of the major changes. So just in case I cut you off at a critical point, was there anything else that you see, and especially drawing on your experience, that you think we're going to see happen differently under the new ART?
Yeah, I think the GAP is the major change, I think. As I mentioned, it can either be an own motion by the president, or a party can apply after receiving a decision from the tribunal. The party would need to show that the tribunal's decision was in error in some way. So it's meant to assist applicants to address errors in the tribunal decisions without needing to resort to an appeal to the federal court. So just in terms of tax matters, I think this presents I think a great initiative. There's now a possibility for an extra layer of protection, if you like, before having to lodge an appeal from an unfavourable decision. So which, as you know, it's quite restrictive when you need to appeal to the court. So a taxpayer can only appeal on an error of law, so it can't be, for example, on an error of fact. So if the tribunal made an incorrect finding of fact. So this may be some very practical help or a stopgap measure, if you like, to prevent unnecessary and often quite expensive appeals to the court.
Excellent. Well, I mean, that's really interesting. We now have an appeal process. There will be an appeal process within the ART. So just to clarify, if somebody chooses to apply to the President for a review of a decision, do they still have a right to appeal that decision to the federal court, or is that closed off?
Yeah, so in that case, there's very strict timeframes. So if we're talking about the situation where a taxpayer has already had a decision from the tribunal and is choosing whether to apply to the President to convene the gap, or considering whether to appeal to the federal court, the thing to keep in mind is that the new Act will essentially stop the clock, so to speak, on the appeal period to the federal court whilst the President's determining whether your matter warrants a review of the gap, because it's not a review as of right to the gap. The President will still determine whether it warrants a review. I think the thing to keep in mind is that the appeal period to the federal court remains 28 days, so it's best to make the application for the gap to the President as soon as possible afterwards, because you don't want to wait until, you know, day 27 to make that application, because whilst the clock will stop, you only have, in that example, you only have 1 day after that to appeal if the President refuses to refer your matter to the gap. So the other thing that I mentioned in terms of significant changes brought about in the ART Act is that respondents or decision makers can elect not to participate in proceedings. So this is probably quite foreign in the tax and commercial divisions, where the ATO and other regulators like ASIC play an active role in proceedings. But as I mentioned, there's a lot under the tribunal's umbrella, so to speak, and a lot of administrative decisions are reviewed by the tribunal without an active respondent. That was certainly the case, I understand, during the robo-debt period for a lot of the Social Security type decisions. So anyway, the new ART Act allows decision makers to elect not to participate in the whole of the proceedings or part of the proceedings. If the matter goes to the gap, though, the respondent or decision maker is required to participate, notwithstanding an earlier election.
So sounds like there's quite a few important timing points there, and that our clients are going to need some expert steering on some of these issues. So you mentioned at the outset, Jack, that one of the things that's attractive about going to the AAT at the moment is that it's a no-cost jurisdiction. Has anything changed about costs, and has the new Act introducing the ART introduced costs as being recoverable in the proceedings before the tribunal?
No, so this was one of the areas that I understand was the source of the most submissions, or a lot of submissions during the consultation process for the new provisions. There's some provision for cost in certain jurisdictions, such as the compensation jurisdiction, so Commonwealth workplace injury type matters, but that was always the case. So no, unfortunately for tax matters, they'll remain a no-cost jurisdiction, so each party will have to bear their own costs. I think the feedback was, by considering changing to allow costs to be recovered, was that it would be really walking away from some of the principles that really underlie the tribunal, so being, cost efficient, and accessible. So whilst there was still, there's still going to be reasonably modest application fees, there's also no risk of being ordered to pay costs if you're unsuccessful, and obviously you won't get your costs if you are successful.
Well, I think that's a very important advantage of going to the AAT, and certainly something that clients do weigh up in making a decision about where to appeal a matter, and in my case it's usually a tax matter. And I think it's an important element of continuing to make the tribunal accessible, as you said. Now, one thing, and often it's in the lead up to a matter being in the tribunal, or it may be something initiated by the tribunal as well, is a form of ADR, of alternative dispute resolution. Is that something that is still going to feature as a part of the new rules and the new regime around the ART?
Yeah, absolutely. So there's no changes in substance to that. So the tribunal still encourages ADR. It's in the new legislation, the preamble to the legislation. It encourages ADR, and they'll continue to have different tools, so mediations, conciliations, neutral evaluations. So they still have the full suite of, avenues for early resolution.
Excellent. And the earlier things can be resolved, often the better. And Jack, what about the small business tax division? Is the new ART still going to have that?
I believe we're waiting on some more guidance about that, but I believe the expectation is that it will remain. What we do know is that the ART will have 8 jurisdictional areas. So it'll have the general is one, intelligence and security, migration, the NDIS, protection, social security, the tax and business, and lastly, veterans and workers' comp will have its own divisions. So each of these will be headed up by a leader, so a senior member who has subject matter expertise in one of these 8 areas. So yes, the tax and business division may still have a carve out for the small business tax issues, so similar to how it's currently accommodated for.
Excellent. So this is another change, Jack, and as tax people, whether you're a lawyer or an accountant in tax, you get very used to change, and I think we become pretty good at adapting to change. So in addition to anything that we've talked about today, are there any other changes that tax practitioners can expect when they are interacting with the tribunal compared to what they might be used to now?
Yeah, the only other, new additional aspect, would be there are some updates to the Tax Administration Act. So the provisions in Part 4C that deal with reviews by the tribunal, because of course the current Administrative Appeals Tribunal Act is modified by certain provisions in the TAA. So one practical change is going to be in relation to T documents, so the documents that the Commissioner is required to provide a taxpayer at the outset of once an application has been filed. The existing obligation is for the ATO to provide all relevant documents. That has now changed, and the new language is that they are to provide documents that are necessary to the review of the objection decision. And the explanatory memorandum has indicated the reasons for that wording change is because the tribunal felt that they were inundated by a lot of very voluminous T documents, and a lot by the time it got to a hearing were irrelevant. So they've slightly tweaked the language in the new ART Act to make it only documents that are necessary to the review. There is going to be an additional provision under the TAA which gives the tribunal the power to direct that the commissioner or the ATO provide further documentation if a taxpayer believes that there's documents that are in the possession of the ATO that are necessary for the review as well.
And finally, Jack, when does this change come to effect, and when do we formally move from the AAT to the ART?
So the official date is the 14th of October 2024, but there's a lot in the works at the moment transitioning over. So the tribunal at the moment, we are seeing some releasing of some practical guidance in the meantime, but the official date is the 14th of October this year.
Well, we'll all be putting a big circle around the 14th of October in our calendars, I'm sure. But thank you so much for that, Jack. I mean, you are a real subject matter expert, and you do an excellent job driving our tax litigation practice at Hall & Wilcox. So thank you for sharing your time and expertise with us and with our clients on this podcast. And thanks to everybody for listening today. As always, please get in touch if you have any questions arising from this webinar. And you can, of course, find our details on our website, our newly renovated website, which is at hallandwilcox.com.au. That's hallandwilcox.com.au, or connect with us on LinkedIn. And if you've enjoyed today's episode, then please rate, review, or follow our podcasts wherever you get or access your podcasts. Thank you once again, and look forward to next time.
This podcast is not legal advice and should not be relied upon as such. You should always obtain legal advice about your specific circumstances.